Hello and welcome to Pulse Maharashtra with me, Vinaya Deshpande. I am the Maharashtra Chief of Bureau of The Hindu and your host for the show. Let's begin with the top headlines of the state. The controversy surrounding Maharashtra Agriculture Minister Manikrao Kokate continued this week as well, even as the opposition sought his resignation as a video clip showing him playing rummy during the monsoon session of the Maharashtra Assembly went viral. Maharashtra Deputy Chief Minister Ajit Pawar has said that a decision will be taken only next week. The controversy surrounding honey trap allegations also continued this week, where the opposition has claimed that the BJP had done honey trapping of several top leaders in order to bring down the Mahavikas Aghadi government. This week, Maharashtra Minister Girish Mahajan gave out photographs of one of the accused with several other top leaders of political parties across the spectrum, even as allegations were leveled against him after his photographs with the accused had surfaced. And now let us take a look at the main story of the week. This week, the Bombay High Court acquitted 12 accused in the 2006 Mumbai serial train blast case, famously known as the 7/11 terror case. It had killed 187 people who were traveling on the Mumbai local trains and had injured over 800 persons. Now, in its verdict, the Bombay High Court has said that the state government or the prosecution had utterly failed to establish guilt beyond reasonable doubt, thereby acquitting 5 persons who were given death penalty and 7 persons who were given life imprisonment, completely discharging them. 9 persons walked out of the prison free this week. But this brings us to several important questions. And the key question is 19 years after the terror attack, are we still away from justice? Do we still not know as to who led these terror attacks in the Mumbai local trains, when NIA and several other police agencies have claimed that the Indian Mujahideen had a role to play in these terror attacks? How is it that the Maharashtra government or the Maharashtra ATS went ahead with a different conclusion? With several holes which have been punched into the prosecution's theory by the Bombay High Court and a verdict which is clearly in their favor, right now the unanswered questions remain. Questions are also being asked about the accountability of state agencies in cases where the prosecution has failed to prove that they have arrested the right people. In order to bring about several perspectives of this debate, which has started after the verdict by the Bombay High Court, I have now spoken with senior advocate Mohit Chaudhry, who represented some of the accused in the 7/11 case, as I have also spoken with a journalist and a current academic, Sharmeen Hakim, who not just covered the trial closely for several years, but also co-authored a book on the issue. Both of them have raised several pertinent issues with respect to the trial which was conducted, with respect to the investigation which took place, and how parallel agencies, two different agencies, came out with parallel conclusions which were completely exclusive of each other and yet went ahead with two different charge sheets. Tune in to these conversations. Hello and welcome to Pulse Maharashtra with me, Vinaya Deshpande, on the Hindu's YouTube channel. Today, I have with me senior advocate Mohit Chaudhry, who represented the accused in the 7/11 case, along with his colleagues Siddharth Sharma and Payoshi Roy. And we are talking about this judgment primarily because of the way, after a wait of 19 long years, the accused were finally discharged by the Bombay High Court. And the Bombay High Court not just discharged them, but also said that the prosecution had utterly failed to establish any guilt. Sir, thank you so much for your precious time for the Hindu. Let me start by asking you, what made the High Court acquit the accused persons in such a heinous case? We've seen a terror attack, serial bomb blast, which ripped through the local trains of Mumbai, killing over 187 people, injuring over 800 people, and for such a sensational case at that time. What made the High Court take this decision?
The rule for adjudication of cases, in theory, do not change depending on the gravity of the crime. That is the theory. In reality, the rules that may apply in adjudicating appeals of ordinary murder are very different to the actual guidelines or the yardsticks that judges employ in adjudicating cases of such magnitude. Let me tell you what I mean. In a normal murder case, in an appeal, the judge may overturn the conviction and acquit the accused because of technical reasons, benefit of doubt, appreciation of evidence. In such cases, the accused and his lawyers do not have to argue that they are innocent. They don't certainly have to show they are innocent because the burden of proof is always on the prosecution. But when it comes to such enormous crimes, and this is as big as it gets, 189 people dead, 700 people grievously wounded, injured, and maimed. When it comes to cases of such enormous crimes, the classical rules do not apply. In these cases, the judges are not going to acquit you after you have been convicted. They're not going to acquit you merely because of appreciation of evidence, a different view being possible, or benefit of doubt, or technical reason. Until and unless they are legally and morally convinced that you are innocent and have been falsely implicated in this case, they are not going to acquit you. And it is only once the High Court judges, according to me, cross this very high Himalayan threshold in their minds that they acquit these 13%.
So, we have seen the trial of this case since the beginning. We have seen all the flip flops and the kind of controversies that surrounded the probe as well. Different agencies giving out different findings. Someone saying it was Lashkar-e-Taiba, someone saying it was IM module. How did the ATS come to arrest the wrong persons, really?
This is what happens when pressure is put on the police. He has in our country a notoriously corrupt police force, which is understaffed, overworked, undertrained, and ill equipped. On top of all that, if you start adding political, bureaucratic, and media pressure, it becomes very, very difficult for them to do their job. Now, the blast occurred, and the pressure was enormous on them to find the people who did it. They couldn't get a clue about who had done this blast. They were thrashing about trying to find something, find someone. They couldn't find anybody. So what did they do? They started calling who they suspected may have done the blast. They started calling them for interrogation. In this case, what they did, they knew that some Simi members were there, and some of these boys were allegedly Simi members. Simi was a band organization. So they started calling them in for interrogation. Then they started interrogating everybody these boys were in touch with. Their family members, relatives, friends, distant connections. And eventually, still when they couldn't find anybody and they were really desperate, they made a conscious decision to falsely implicate these persons. They arrested them in this case and they fabricated the entire evidence against them. Now, what had happened is that after some time, they filed charge sheets consisting of wholly fabricated evidence, and the trial started proceeding or was about to begin. And at that time, this was done by the ATS. And then at that same time, another wing of the Mumbai police, headed by that time Rakesh Maria, that is a crime branch, filed, arrested the IM accused for the offense of bomb blast in Gujarat and other parts of India, for which an email had been sent from Mumbai. And Rakesh Maria and his team arrested these IM accused, including Sadiq Ikrar Sheikh and others. And then while they were investigating them, they found evidence to show that these IM accused persons had committed the train blast, for which the other persons were wrongly being prosecuted. They filed charge sheets against these IM persons, saying that they had committed the train blast. Among the other things, the confessions they used in evidence in the charge sheet stated that these train blasts were committed by these IM persons. These charge sheets filed by a crime branch were given sanction by Maharashtra government. Can you imagine? So you have two wings of the Mumbai police filing contradictory charge sheets against mutually exclusive groups of persons for having committed the same offense. And the most startling thing is that both these charge sheets were filed and prosecuted by the same prosecutor in the same court. So you have the same prosecutor in the same court before the same judge in one set of proceedings saying that this offense has been done by these 13 boys, and in another set of proceedings before the same judge filing evidence which says that this train blast has been done by the IMP. So this
So,
is
what
not
is ridiculous is that, at one point in time, the trial court also dismissed the statement that was given by one of the operatives of IM.
you see, if this doesn't make a mockery of justice, I don't know what that. Please think of it. Never mind the dishonesty of the police. Let us ignore the the conflict of interest of the prosecutor. Let us just focus on the trial court judge. What was he doing? One wing of Mumbai police is saying this offense is committed by the 13 boys. Another wing of Mumbai police is adducing evidence to show before him, saying that this offense has been committed by the IM. Is he really actually trying tying that proverbial clock around his eyes and saying, I can't see anything, I'm blind? This has been made a mockery of justice simply because he has chosen to blindly rubber stamp the entire ATS case. It has cost, it has damaged the judicial institution, it has damaged the credibility of the judiciary, it has damaged the institution of police investigation. The public faith in the police has been damaged, and these boys have lost 19 years of their lives. This could have been stopped at a very early stage, but it didn't happen. Now, what had happened is that by the time the crime branch filed these charges, the ATS and the Mumbai police, under the then Commissioner A.N. Roy and the Commissioner, getting Joint Commissioner Raghuvanshi, had gone so far down this line against these other persons, and so much evidence had been fabricated that it was too late to turn the clock back and now say yes, this offense has been committed by someone else. So they persisted with this court, even at the expense of allowing the real perpetrators to go scot free. Vinaya, I hope victims realize that punishing the innocent for a crime they did not commit is not in the victim's interest. In fact, it hurts society more than anything else can. Please remember one thing: the conviction of the innocent for a crime they did not commit is an insurance policy for the actual culprit. Once a person is convicted for a crime, somebody else cannot be convicted for the same crime. So the moment you convict an innocent person for a crime, that becomes an insurance policy for the actual culprit. And by persecuting and prosecuting and pursuing these innocent persons, the ATF and their superior officers have compromised national security. They have played with the lives of innocent people and they have betrayed the trust society and the victims have placed on them. They are answerable.
And yet, sir, when it comes to accountability, that is one thing that has been woefully lacking. Several people that we have spoken with before, after the judgment, have said that there should be some system in which the agencies which investigate such cases should hold accountability. What are your thoughts?
There is so little regard in this country for the rule of law, even among those who are supposed to implement the rule of law, bureaucrats, politicians, police officers. There is so little regard for the rule of law that accountability is a low priority in our country.
But
The
how should
officers
that be brought about?
routinely judges in the High Court and Supreme Court note that evidence is fabricated. Routinely. Is any step ever taken against any of the officers who have fabricated that evidence? These directions, these observations are all ignored. And which is why we are in the place we are today. And 19 years later, we find that in such a heinous offense, the actual perpetrators are still at large and have not been punished. Instead, some dummies have been put up to satisfy the public and the victim.
So, if we could elaborate more on this, because it's an extremely agonizing point that the fact that 12 persons have been acquitted is a fact of relief, but it's also true that there's no justice really in this case, because we still do not know after 19 years of such a heinous crime as to who did it, who was responsible for it. One of the points that the Bombay High Court judgment also talked about was how the CDRs were destroyed. If you can talk to us about some of the fabricated evidence, about how evidence was not brought on board.
Vinaya, in this case, the evidence that was produced by the prosecution is so patently and obviously false and fabricated that any layperson can see it if they are willing to open their eyes. That's all. You only need to open your eyes. If you are willing to open your eyes and look at the evidence, you will decide and see for yourself that it is false. Let me give you a few examples. Prosecution produced evidence of confession made by these people to DCP, senior level police officers. In normal cases, confession to police officers are not admissible, but ironically, for the more serious cases, they suddenly become admissible under our law. Never mind. That is the way it is. Order. Now, the reason why, under general law, confessions to police officers are not admissible is that the police cannot be trusted to record a confession honestly. Now, just see what has happened in this case. There are 10, I think, confessions in this case. Most of them are copy paste. Cut identical large portions of the question and answers before and after the confession on 2 consecutive days. Large portions of the directions which are written by the officer supposedly recording the confession on impromptu, on his own hand at the spur of the moment, his formulation of the questions, his recording of the answers, the orders which he has given, which are written down, word to word identical. How is it possible? Across consent. And the High Court has noted it has given the evidence it has accepted those copy paste sections in the judgment. Vinaya, you must have seen it. You can show your viewers the table that has been put in the judgment, showing passage after passage, identical. Then different, and it is not as though only the questions are identical, even the answers are identical. Police had produced top witnesses to prove vital aspects of that case. So, for example, they produced a witness called PW74, Vichal Kishore Parmar. He says that he was traveling in the train on that day and he saw a fuse number 4 etc. planting a bomb in the train, a packet containing a bomb. And he remembers and he recognizes him, he tells the court. In cross examination, it comes out that this so called passenger has been routinely appearing as a witness for the police in previous cases. And the most recent was just a few months before the train crash, he had participated in a panchnama as a punch witness for the police. And not any police, the same police officers who are investigating the case. Now, just see, it doesn't stop there, it gets even better.
So,
So,
key statements have come after 100 days after the incident.
see, I'll tell you that you are right. But let me come to that in a moment. Let me just complete this point about Vishal Kishore Padma. So when the police is not able to get any evidence, they suddenly produce this eyewitness, Vishal Kishore Parmar, who says, I was in the train and I saw this person at number 4 planting this packet and leaving it and getting off the train. Now, as I mentioned to you, he is a stock police witness. He has appeared for the police. What are the chances that he could have actually also been a train passenger in the same case? Now, just see further. The police produced another witness called Mukesh Rabadia. And they say that he was a punch witness for the house search of Muhammad Ali's house, in which the police officers found RDX traces and swabs from under his bed. Muhammad Ali's bed in his house. RDX swabbed and traces were collected from Muhammad Ali's house. So this Mukesh Tabadia. It so happened that Mukesh Tabadia is the employer of Vichar Kishore Parmar. So the employer is a punt to the seizure of RDX, and the employee is a eyewitness to the planting of RDX, and neither know that each other is involved in this case. And both have worked at Panchayat for the same police officers in the past. Can you believe this? Can any normal, any person with minimal intelligence believe this? It is an insult to intelligence. And yet, that nonsense fabricated evidence has barked bucked and it has received a rubber stamp of judicial, of the trial court judge. I can give you more such examples. Let me talk about the TDR that you mentioned. From the time that these boys were arrested, they were repeatedly produced for remand before the magistrate and before the trial court. In the remand applications that were repeatedly filed by the police, the ATS, those remand applications said that these people are the actual culprits, that they have been in touch with each other on the phone, that they have been plotting these bomb blasts with each other, they have been in conspiracy with each other, or they have been talking on the phone, that they have been in touch with the Lashkar-e-Taiba in Pakistan, where they had gone for arms training, and they are in telephonic contact with their handlers, and that we have obtained their call data records, and the call data records are being analyzed. They say this not once, they say this 10 times, at least. And yet, when the time comes to file the charge sheet, the most vital piece of evidence against the accused, the call data record, which would have not only shown who they are talking to, but also would have shown where they are on the date of the offense, whether they are at church station planting a bomb or not. This most vital piece of evidence is not produced in the court along with the charge sheet. Now, please remember one more thing. In this charge sheet, the police ATS have named those Lashkar-e-Taiba 66 Pakistanis as wanted accused and listed some names and said these are these Pakistanis. And against whom we want the court permission to carry on investigation. Now, even against them, those wanted accused, the CDR would provide vital evidence. Now, think of it, they say they have collected the CDR, they don't file it in the court. During the next few years, the accused makes 6 to 7 applications in the court asking, please give us copies of the CDR. And for each application, the special public prosecutor replies, we are not relying on this, we will not give it to you. Now just think of it, they have collected evidence. And they are saying, he will not give it to you. Why? Why are they so strong? Finally, the accused makes an application to the police, to the court and says, sir, if they, at least take it from them and keep it with yourself because they are going to destroy it. This proves our innocence, the CDR will prove our innocence, they don't want to give it to us, but you please keep it with yourself. The court rejects that application. Finally, we go to the High Court. In the High Court, the Advocate General appears. And he says, of course, you cannot deny them the CDR. Very fairly concedes the point. You cannot deny them the CDR. The CDR has to be given to them. So the judge in the High Court, the Honorable Judge says, yes, please give it to them. He says, okay, next week we'll give it to them. I'll produce next week. Next week, they appear in court and they file an affidavit saying they have destroyed the CDR. Now, please ask yourself, if they didn't want to use it, don't use it. What is the need to destroy it? Please ask yourself, what is destroyed? It is only if it is against you that you destroy it. If it is, genuine, if it is not affecting your place, why did you destroy it? And please think.
I think it was Darius Khambata who represented the state at that time. And irony had it that probably it was Rakesh Maria, who was the ATS chief, who had, put up that probe of IM involvement in this.
Your memory is absolutely right. You're absolutely right in your memory in recalling this incident. And the names you have given are correct. They were anyway, never mind. They destroyed the CDR. Think of it. There is a case pending against the wanted accused, against whom investigation is still continuing. And the CDR is also evidence against them. Do you think the police would have destroyed it? Alright. Now just see the extent to which they have gone. So we asked for the CDR, they say we will not give it to you. Alright. He makes an RTI application to MTNL asking for copies of our own CDR. The ATS writes to MTNL saying don't give it to them. Just see how scared they are of the truth emerging. You know, I can show you evidence and it's there in the judgment of torture. Brutal, absolutely inhuman torture inflicted on these persons by the police. It's vividly recounted in the judgment and in the evidence. And that is how these false confessions, this fabricated evidence was produced on record, and how these convictions have been obtained. In the face of the most low level common sense, they have been convicted. This is not a case of benefit of doubt or, maybe they have done it, maybe they have not, burden of proof is on the prosecution. They could not produce enough proof that this is a case of innocent persons falsely prosecuted, falsely implicated, and falsely convicted on the basis of fabricated evidence. It's as clear as
So,
daylight.
but how do we make sure that we prevent such miscarriage of justice in the future?
The first thing the victims need to do and society needs to do is to insist that the government forms an independent SIT, a special investigating team, or a commission of inquiry, which looks into how this has happened, which surveys the evidence, which looks at the evidence collected by the ATS and how it has been collected, looks at the evidence collected by Rakesh Varia's crime branch. You see, one more thing. Police forces all over the country, in Delhi, in Andhra Pradesh, in other places, have filed charge sheets stating that the train blast was committed by the IM people. All these police forces are all wrong. Think further, I'll give you one piece of startling information. Till today, on the NIA website, the NIA is saying that the train blast was committed by the IN. The NIA is the premier investigating agency of the country. It is created under central legislation to investigate crimes involving security of the nation and terrorism. Their claim is that this train blast was committed by IN. Is everybody wrong? Vinaya, I'm going to email you links to the NIA website and I'm going to show you those documents. Please show your viewers those documents in this program. If it's possible, please show them those documents. I'm going to send them to you right now. Just hold for one minute. Is that okay?
Yes, and we will absolutely show this. After all these things, the fact that several other police forces also investigated, NIA also said that it was the IM which was responsible, and yet we had the state government which came on record to say that the judgment of the Bombay High Court is shocking, and it takes less than 24 hours for the state government to knock on the doors of the Supreme Court and to get a stay.
This is the thing. The scale doesn't mean anything. It's not a comment on the judgment. Let's keep the scale aside. This is the thing. These people are willing to compromise national security just to protect their reputation. Please understand and see what's happening here. They are willing that the actual perpetrators remain at large, but they should not be embarrassed and it should not be told that they have committed this. They never admit that they were party to the fabrication of evidence or this happened. The government should admit its mistake. The government should be large enough and admit its mistake. Yes, okay, our officers did this. Now we will go after the right people. But even now, they are not doing justice to society or to the victim. Can I send you that email when I am showing that the
Yes, sir.
NIA
We can do it once we roll the interview. Because this just leaves us with a very heartbreaking last question that I would like to come to. What is the way in which victims can really get justice? Because really, for all the family members of those who have lost lives, and for all those people who have faced lifelong damage, who've been scarred, who've been traumatized, there is no justice. How does one ensure that?
two things that I have. the victim must, the state government must constitute a high level in the SIT consisting of high ranking independent police officers, bureaucrats, not just police officers, purely police officers, bureaucrats, retired judges, to look into this and see what has happened. That's one. And second, they must go after the right people. And third, they must compensate these poor boys whose lives have been ruined. Their families, can you imagine the untold misery, shame, and hardship they have faced? Children have grown up with the sense that their father was a terrorist. It is not something you would wish on your worst enemy. We have done this
and
to our own
and people
people.
who were daily wage laborers, who were vegetable vendors, who were
Whom this is done, Vinaya, because they cannot fight back. It is always the poor that they would never dare do this to a rich person.
on that note, sir, it's extremely heartbreaking, and I wish to really thank you for your precious time and for opening up the several perspectives of this key case, the process so far, the 19 agonizing years, and the kind of persecution that was faced by all the accused who have now been acquitted. Thank you so much for speaking with the Hindu. I also spoke with Sharmeen Hakim, who has co authored a book on the 7/11 train blast trial case. Let's listen in. Sharmeen, thank you so much for speaking with the Hindu. And let me first come to you to ask about the accountability of the police officials who have investigated the case. After the verdict of the Bombay High Court, several questions are being raised about the probe which was conducted, about the way in which 12 persons who have walked out of the prison, and though the Supreme Court has given a stay on the verdict right now, they've also said that it does not mean that the 12 persons should be taken to jail. What does it say about the accountability of the officials who investigated these crucial cases?
Hi, Vinaya. Thank you so much for having me here and thank you for the question. So I feel that the High Court's judgment is in a way incomplete because it does not really fix accountability on the officers that probably have botched up investigation, because of which we are in a place where we probably don't know who the real perpetrators of the blast are, and we are asking so many questions, seeking justice not just for those who died in those blasts, but also people who have spent 19 years in prison, uh, just trying to reiterate their innocence. The families that have been left absolutely without any kind of support system, trying to follow between. People have been divorced while they are in prison. There are kids that have been left just because of the unaccountability of investigating officers, and because the High Court wasn't probably able to fix proper accountability on what went wrong and who did wrong. So probably some kind of compensation, and compensation is only the beginning of it, but it can also um, fixing accountability can also act as a deterrence in such cases of terror attacks of this scale.
That brings us to the next point, Sharmeen. As a journalist, you have covered this case quite closely. In fact, there was a time when both of us had covered this case when the trial was on, and there were several questions that were being raised. Even at that stage, remember the kind of flip flops, the kind of investigation that came forth. Different agencies came up with different kind of conclusions. So from day one, this probe has been in the line of question. What do you have to say?
Correct. Uh, Once again, thanks for the question, Vinaya. So basically, there are a couple of things that went uninvestigated, or that also leaves us with a couple of questions. So, for instance, the first arrest that was made in the case, that was made on 20th of July, it was Kamal Ansari who was arrested from Bihar, and the ATS said that it recovered like half kilo of RDX from him, etc. But the next arrest, and he had no link to Simi, that is said to have coordinated the blast along with in collusion with the LET. So the next arrests that were made in the case were made on September 29th, and between September 29th and September 30th. So nearly 2 months of probably calling these people for investigation. And then at one point, everybody was arrested, and the ATS said that it had absolutely cracked the case. And right after the Maharashtra Control of Organized Crime Act, the MCOCA Act was imposed, suddenly everybody seemed to have wanted to confess to the crime, even though the moment they were presented in court the very next date, all of them retracted from their confessions, and they gave very detailed accounts of the torture that they were put through in ATS's custody, and in police custody. So not just that, in 2008, the Mumbai crime branch was a different investigating agency. They busted the IM module, which is the Indian Mujahideen module, and that module took responsibility for all the blasts between 2005 to 2008. And they said that they executed these terror attacks in response to the Godhra riots of 2002. But it seems that instead of an independent agency actually investigating this link, it is the ATS again who took Sadiq Isra, who sought his custody in February 2009, which is the next year. And a couple of months later, they said that we haven't found any connections to him and the blasts. Um, but but the question remains that if there was an independent investigating agency that had probably probed this, we may have we there was a possibility we could have had a different outcome as to what we had. It just doesn't end there, because the co-founder of Indian Mujahideen, Yasin Bhatkal, alleged was arrested in 2013. And again, the links between Indian Mujahideen and these blasts came to the fore. But once that link was pursued, and it ended with the interrogation of Sadiq Isra Sheikh in 2009, uh, that entire conversation went into cold storage. So the idea is that if it was an independent investigating agency that had actually gone ahead and probed the case, we may have had a different outcome. And to your point, in the 2008 Malegaon case, when the saffron terror module was busted earlier, a set of in which BJP MP Pragya Singh Thakur is also an accused, and I think it awaits judgment now. In that case as well, the case was transferred to the NIA, and then a different set of accused were actually arrested, and an independent agency probed the case. So probably a similar thing should have been done in this case as well. From my investigation, especially while writing about the book and also reading the ATS's 10,000-page charge sheet on the case, it made these accused appear larger than life. Like with training camps organized, they took training here in Pakistan, and they recruited this one and that one. Now, for instance, I'll give you the example of again Kamal Ansari, who's unfortunately passed away, and he couldn't see the verdict being passed in his favor. But they said that he was sent to Pakistan as an LET operative, and under the guise of and he was indoctrinated there. And he has been convicted of planting a bomb at Matunga. Now the point is that he was merely a vegetable vendor in Bihar, and his family was so poor that neither could they make it for the judgment or could be in touch with him at any point, or help him to get any sort of medical attention or assist with anything while he was suffering during COVID, which is when he passed away. So not just him, for example, Ehtisham Siddiqui was merely an engineering student. Another person was repaired mobile phones. Muhammad Ali, in whose house the bombs were allegedly assembled, he he lived in a shanty in Govandi. So his shanty was so small. His contention was that people wouldn't even fit in my house to assemble those bombs that they say were assembled in my house. It was so tragic that during the COVID pandemic, a lot of these people, so in Muhammad Ali's family, they had some relatives, or I think his brother or somebody who passed away, and his case didn't even come to a hearing. By the time his plea to get this to 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 be allowed to visit, or the last rites of the family member, by the time that case really came up for hearing, by then it had become infructuous because it had become so late. So it came more than a year or two later. So even as accused, even as convicts, there are certain rights that you have, but all of that lives only in the realm of books, and it is never actually in letter and spirit, which is very unfortunate. To say that people who are probably appear and made larger than life are probably are just like ordinary people doing ordinary jobs, but when we want to fix accountability, then these are the methods in which it is done, that we make it look that we make it look so larger than life that it's difficult to negate. And to your point about eyewitness accounts, so the Bombay High Court observed that a lot of witnesses were examined right soon after the blast, and their testimonies were recorded, and they gave, based on which sketches were made of the perpetrators of the blast. And it was not these people who were examined, but people whose testimonies were recorded 100 days after the blast, and then they were examined in court, and then multiple problems were found in those testimonies. For instance, one of the eyewitnesses, uh, alleged eyewitnesses, said that he went and he probably saw a man holding a bag, and then it was all on how he couldn't have been present. So through our Right to Information Act, Ehtesham Siddiqui, who was accused of planting the bomb, he found that the person this eyewitness wanted to visit in a hospital nearby had not probably reported to duty on that day, so it was not possible. There was also inconsistencies in the names of these eyewitnesses, and there were just so many inconsistencies with other eyewitnesses as well, that the defense basically built that case negating the stories of these eyewitnesses through right to informations that were filed in various government offices, which also raises questions about the veracity of the evidence that is being produced in court in a case of such magnitude.